So again, good evening and welcome to the January membership meeting of the Cooperatives and Condominiums Advisory Council. For those of you who don't know me, I'm Tim Foley. I'm the CEO and Executive Vice President for the Building and Realty Institute, and I am your Zoom moderator tonight. Before I turn it over to CCAC Chair Jane Curtis to introduce the topic and the speakers for tonight, a couple of housekeeping notes. First of all, as you've just heard, this will be recorded. Typically what happens is we send out a highlights reel style video of some of the highlights of the points that the speakers have made. That should follow and go not just to the folks who've registered tonight, but to everybody in our CCAC mailing list within a couple of weeks. Additionally, if the speakers are okay with it, and they use PowerPoints, we're happy to share those slides specifically with folks who have registered for tonight. That's item number one. Item number two, you will be receiving tomorrow by email a post-program survey. Please do fill it out. We take those suggestions on there very seriously and are constantly looking to improve ourselves. Number three, I am going to keep most of you on mute. I will have an itchy trigger finger for background noise of any sort, and we'll probably be putting you on mute quite frequently. We are expected to have over 100 attendees, and so this is necessary so that everyone can hear the speakers and get the information clearly. However, we will have time for Q&A over the course of the evening. The best way for you to indicate that you would like to ask a question is for you to use the chat feature within Zoom, which is on your Zoom toolbar. Which way you're getting Zoom, guaranteed there is a chat button there. You can either send a message directly to me, or you can send it to everybody indicating the question that you would like to ask. And if it's a particularly complicated question, you don't want me to read it aloud, you would prefer to read it yourself aloud, just indicate that too. When we get to the Q&A section, I will be taking folks off mute so that they can answer their questions. The second best way to get my attention, if chat is a little bit too much, is to use the raise hand feature for those who know how to do that. The worst way for you to indicate that you have a question is to wave at me from your window. We have several screens of participants tonight. I will probably not see you, and your question will not be asked, and that would be sad. And why be sad? So without further ado, I do want to turn the festivities over to the CCAC chair, which is Jane Curtis. Jane, take it away.
Thank you, Tim. And you guys, pardon my background noise. I will be brief. I want to welcome you to our first membership meeting of 2024. Tonight, the CCAC will, for the first time, present legal guidance on a somber topic that our board of directors thought we all need to be prepared to address. And judging from the turnout here this evening, you all agree that it's an important one. We thank you very much for being here. And now I'd like to pass the mic to Associate Executive Director Jeff Hanley to introduce our program and speakers.
Thank you, Jane, and thank you, Tim. Good evening, everyone, and welcome. We've got two very knowledgeable speakers covering two very complex topics, so we will get right to the main content of our program. Our first speaker this evening is Richard Klein. He will address the topic of what to do when a shareholder or unit owner dies. Richard is a partner at the law firm of Klein, Greco, and Associates, LLP. His experiences in our region's business community are long and they are varied. He became a real estate attorney after having worked for several years in his family's real estate business, where he was involved in real estate management. He also oversaw the leasing and sales of both commercial and residential properties. Richard has worked in the real estate litigation division of the New York City Law Department. In that position, he worked closely with several city agencies on various real estate matters, including the New York City Housing Preservation and Development Agency, the Human Resources Administration, and the Economic Development Corporation. As a result of his performance while at the law department, Richard was recognized by the Committee of Municipal Affairs of the New York City Bar Association and awarded its prize for outstanding achievement as an assistant corporation counsel. After that position, Richard worked at a small firm on Long Island where, in addition to real estate, he also practiced criminal and matrimonial law. He eventually became a solo practitioner focusing solely on real estate. On his own, Richard's practice included residential and commercial transactions, commercial leasing, bank representation, the general governance of cooperative and condominium buildings, and real estate litigation. Richard successfully maintained his solo practice for 16 years until he was solicited to join a Manhattan law firm as a partner to head up its cooperative and condominium department. While there, he oversaw the legal representation of approximately 75 cooperative condominium buildings. Again, Richard will address the topic of what to do when a shareholder or unit owner dies. At this point, I am very happy to introduce Richard Klein to the CCAC membership.
Well, Jeff, thank you very much for that introduction. I really appreciate that. And thank you to also Tim and Jane for asking me to do this presentation tonight. I really appreciate it. And I thank everyone on this Zoom for showing up. It's really great to see so many people in attendance. As Jeff said, my topic is what to do when a shareholder or unit owner dies. And I wanted to start the presentation by saying that I've really been dying to give this, but my daughter said that that's a stupid dad joke and I shouldn't do that, but I'm sorry, I just couldn't resist. But seriously, it is an important topic. And I guess Jeff, Tim, and Jane are really in touch with what's going on because, you know, as I was preparing just this past Sunday, the New York Times Sunday real estate section, they always have a Q&A that they feature. And this past week's Q&A was from a co-op shareholder who wrote in asking, apparently two of the shareholders joining his apartment had passed away. It was months ago, but he still has odors in his apartment and the management won't do anything. And what should he do? And so, you know, he got a short answer, but I'll be a little more detailed here tonight about what happens when a unit owner or shareholder dies. And there are certain issues that come up in that situation. And I find that it sometimes depends, you know, how you're going to deal with it depends on what the status is in the apartment. So for example, if you have a shareholder or a unit owner where there's a spouse or a partner who's also on the stock certificate or on the condominium deed and lives in the apartment, obviously the issues are, you know, there are still some issues, but you know, you have someone who's still responsible for paying the charges to the building. You have someone that you can talk to about transferring. You don't have to worry about, you know, personal property being in the unit. So that's, you know, one type of situation. Even if the spouse or partner is not on the stock or on the deed, you know, as long as there's someone living there, you know, if there are issues that come up, you have someone to go to talk to and try to resolve these things. I find that the more complicated and more interesting problems come up when there's a shareholder or unit owner that passes away and they live alone and there's nobody else on the stock or on the deed and you don't necessarily know who to go to. I mean, sometimes in that situation, there is a family member or a close friend that steps forward and reaches out to the board or reaches out to the property manager to try to help resolve things. But there are often times when no one steps forward. And what do you do? So for example, I've had situations where a property manager will call me and weeks have passed and all of a sudden there's this tremendous odor on the floor or in the lobby area or somewhere. And they are able to determine that it's coming from a particular apartment and they don't know whether they should open the door or not open the door. So, you know, we go through the operative documents of the building, whether it's the condominiums declaration or the co-op's proprietary lease. But really, we view that as a situation that's somewhat of an emergency. And we would advise that they should go into the unit and see what's going on. And you'd be surprised. And, you know, we've had a few situations where they walk in and there's a body that's been, you know, laying on the bed or on the floor. and has been dead for several weeks. And but I just recently had a situation in Brooklyn where the shareholder lived alone, passed away on the floor. And apparently, if he had passed away on the bed, it would have been a better situation. But because it was on the floor, all these insects and cockroaches and vermin came through the floor and started to eat away at the body. And it was very, obviously a shocking situation, but they immediately had to get the police and EMS there to remove the body. We had nobody to contact, but we eventually found a daughter who came up and was trying, wasn't from New York and didn't know what to do. So we assisted her. We had to bring in actually one of my co-BRI members, Jane Ann Savelli, who works at ServPro. We arranged for ServPro to come in and do a massive cleanup of the apartment because it was just in terrible shape. But we were lucky in that situation that there were children who showed up to help us out there. But, sometimes the body is removed and you have issues of personal property. What do you do with that personal property? You're always trying to reach out to people to see who can help you out in these situations. But when you don't have somebody, personal property becomes an issue. And obviously the biggest issue is, who's paying the charges. When you have someone in the apartment or you have a representative from an estate, hopefully you have someone who you can contact. They're making the monthly maintenance charge or common charge. But what do you do in a situation when, they're not paying, there's no one to contact, and the arrears are starting to build up? You want to get on top of that as soon as possible, because the longer you wait to do something, the arrears just keep accruing and it becomes more and more of a problem. What to do? We've had situations in both Brooklyn, Manhattan, where we reach out to what's called the public administrator. Every county has a public administrator's office. And what they did in the Manhattan apartment and in the Brooklyn apartment, they go into the apartments, they, literally snoop around. They have permission to do that. And they will try to find out whatever information they can to see, is there anyone that they can reach out to? They'll go through drawers, they'll go through closets, look at, we had in the Brooklyn situation, they were going through bank books to see who might be named in the bank books besides the shareholder. In the Brooklyn situation, they were able to ascertain a relative, and that relative, they reached out to that relative, and that relative got an attorney, and now they're in the process of doing the estate work so that they can get moving on the apartment, and they're starting to pay the arrears. In the other situation, they couldn't find anybody, and there's a law firm that represents the public administrator, and they are now moving in surrogate's court for them to be appointed the administrator of the estate, so that they can start at least to do whatever they need to do to sell the unit and stop the arrearage. So that's usually my biggest problem when dealing with someone who passes away. No one to contact, and they're not, obviously nobody's paying. So you want to get on that as soon as you can. And then, other than arrears, it's, hopefully you're gonna at some point be transferring the apartment because you want to get if shareholder lived alone, you don't want an empty apartment. So you want to make sure that when they're ready to sell, they have all the proper documentation. And from an estate, when someone dies, that you're going to have the estate doing the sale, and whether it's the public administrator or a family member who's appointed as administrator if there's no will, or executor if there is a will. When the time comes for them to close, you're going to want to make sure that there's proper paperwork submitted to the co-op and to the transfer agent. So we'll review that. We want to make sure that there are what's called letters testamentary to show that this person has the authority from the surrogate's court to do the transfer. We want to see the death certificate just to have it in our folder to confirm, yes, that this was the shareholder and this was the person who passed away. If it's an estate and there was a will, We want to see a copy of the will. If you also want to get from, there are estate taxes that could be due, so we want to see from New York State a release of a state tax lien so that we know no taxes are due and the apartment could be sold free and clear of any liens. For the IRS, we'll take an affidavit that they don't have to go to the IRS to get any paperwork, but we would do that by affidavit. And, and then you're ready to transfer the apartment and get a new shareholder in there. I also find some of the issues that come up is that when someone, when the shareholder or unit owner, well, this is more in the co-op situation, when a shareholder passes away and I'm the beneficiary under the will, sometimes I think I'm entitled to move into that apartment. That's not how it works in a co-op. In a condo, it's different. In a condominium, you own the real estate. You can make provisions for it in your will that if I pass away, it goes to, my nephew or my son or niece or whatever it is. But in the co-op situation, you can make that provision in your will, but the co-op doesn't necessarily have to abide by that. Depends what they have in their proprietary lease. Every proprietary lease has a paragraph about assignments, and it will say when board approval is needed or when board approval is not needed. And usually there's a subparagraph about what happens when a shareholder passes away. Most leases will provide that it can automatically go to a spouse or a partner, a domestic partner, without board approval. Some are a little more expansive and also include a child or a parent. But beyond that, anyone else would need board approval. So just because somebody is named in a will doesn't mean that they get to move into the apartment and take it over. It's still subject to board approval. So they would be entitled to the proceeds from the sale, but not necessarily be able to occupy the unit, become the owner. So, those are really the issues I've been dealing with, getting rid of bodies, dealing with arrears and the transfers of the units. I think the biggest thing for me, what I now advise my buildings, and I see actually one of my board members is on this Zoom, and she was the one who really got me focused on this. It's very important that when you do closings, if you take nothing away from this talk, but this is something you should take away from it. Emergency contact forms are really helpful. When someone buys an apartment, your transfer agent should have them fill out a form that says in case of emergency or in case someone passes away. These are 2 or 3 people that we can contact who will know what's going on and will be able to help. And I find we now try to do that with our closing packages every time a new owner buys in. And then, you need to check up on it periodically to make sure that the information is still correct. Because if you have that, it will resolve a lot of the issues that you could be dealing with, having somebody to reach out to and contact. Yeah, I see a question. Advice about accepting, I'm sorry.
Richard, do you want me to read it for you?
Yeah, that would be helpful. Thanks, Tim.
Advice about accepting payment from a unit that is no longer coming from the deceased shareholder, but from a family member who may or may not move in. We like that the bills are still being paid, but not sure if we are de facto granting tenancy rights to that family member.
In a rental situation, I might be a little concerned about that, but for a co-op or a condominium, I don't think that transfers any ownership rights to anybody because they're paying the bills. I would say accept it, be glad that someone's paying, and I don't think that gives them any rights to the apartment.
There's another question. If a shareholder passes and the beneficiary who lives somewhere else has a relative move in without board approval, what can we do?
I would, just like with any other situation, I would send a notice secure and say this is an improper occupancy. Technically, I guess maybe I would say it's a sublet, even though the shell, in the way it is a improper sublet, because the estate's allowing somebody to move in, or say you can't do that. And if they don't cure, we would take steps to terminate the lease.
So maybe we can move on to our second speaker and then have Q&A with both of you gentlemen at the end. Jeff?
Thank you, Tim. Richard, thank you. Great job. Great job. Our second speaker tonight is Russ Jellinek. He will address a series of subjects: trust, estate planning, and the transfer of shares in a co-op. Russ is an attorney with the law firm of Geist, Schwarz, and Jellinek, PLLC. He provides counsels to individuals on estate and trust administration and planning issues. He has extensive experience in surrogates court practice in litigated and non-litigated matters. Russ also represents individuals, businesses, commercial institutions, and cooperatives in real estate transactions and daily operations. He has written several articles for the Westchester Bar Journal on diverse business-related topics and later served as managing editor of that publication. Russ is a member of the New York State Bar Association, a former board member of the Westchester County Bar Association, and a past president of the Mamaroneck, Harrison, Larchmont Bar Association. He is admitted to the New York and Connecticut state bars, as well as the U.S. District Courts for the Southern and Eastern Districts of New York. Russ, again, will address trust, estate planning, and the transfer of shares in a co-op. At this point, I am happy to introduce Russ Jellinek to the CCAC membership.
Thank you very much, Jeff, for that kind introduction. I'll also add, I guess it wasn't in the bio, but I also represent General Counsel of the Westchester County Public Administrator. So I'm very familiar with some of the topics that were discussed previously by Richard and how the public administrator gets involved. So at the end, when we're in the Q&A portion of this, I'm happy to shed some light on the inner workings of the public administrator's office, as well as I've been doing that for about 20 plus years now. So that's stated, as that said, I am a member of the firm Geist, Schwarz, and Jellinek, one of the founding members. We are fortunate enough to represent numerous co-ops and condos and HOAs, but for purposes of tonight's discussion, I'll focus on co-ops. And we represent co-ops in representing the, advising the boards, as well as acting as a transfer agent for many of our clients. It's nice to see a lot of familiar faces in the audience today. I see many of our clients are present today, board presidents, so it's nice to see smiling faces. I've been asked to spend a few minutes discussing trust, estate planning, and transfers of shares in co-op into a co-op, which is really going to be the main focus, but I will touch on those other two topics as part of the discussion. Over the years, there's been an ongoing trend for shareholders as part of their overall estate plan to request that their co-op shares be transferred into a trust. Typically, you'll see it transferred into what's called a living revocable trust, but in some cases, they also try and put it in an irrevocable trust, which create some different issues. The reason why, from an estate planning standpoint, is that people essentially want to avoid the probate or the administration process, which would mean having to go to court and get a fiduciary appointed to deal with the transfer of a co-op upon the death of a shareholder. So it's really an attempt to avoid that process by creating a trust which dictates how at least in some part, how the co-op will be transferred. That said, moving on to actually transferring the shares to a co-op during the shareholder's life, such transfers are really they are subject to co-op board approval. The board would be making an accommodation for that shareholder. The shareholder does not have a right for to make that transfer. It's really up to the board and whether or not.
Thank you.
whether or not the board feels as though it would be appropriate to make that a common accommodation. Historically, boards were very reluctant to allow such transfers. However, most of the co-ops that I represent are warming up to that idea now, provided that the co-op is adequately protected. Years ago, it was, the amount of requests for transfers were few and far between. Now it's almost a regular occurrence. I would say we get requests for transfers 1 or 2 a week now. So it's far more prevalent than it used to be. You also need to keep in mind that if there is a lender involved, let's say you have purchased a co-op and then down the road you wish to transfer that co-op or the shares of the co-op, you're going to need to get not only the co-op board's approval, but you're also going to need the lender's approval, which is not always easy to accomplish. That becomes, in some cases, a very difficult task. So that said, what areas is the board concerned about in order to make sure that they are protected? There's really 2 major areas that co-op boards are concerned about. The first is making sure the co-op is able to control who occupies that unit. You want to make sure that whoever is in there is the actual shareholder and that person has the right to be there. So that's one very important concern. And the second is financial. The board wants to make sure that if they go in default on the maintenance, that there's a remedy in order to collect the arrears that start to accumulate. So those are the focus of what we try to do to make sure that the board and the co-op as a whole is protected. Now, how do we address these 2 major concerns? And I think, the best way to sort of discuss it is to go through the normal process that we encounter on a regular basis. So a shareholder, or in many cases, the shareholder's attorney, will reach out to us and express their interest in transferring the shares to the trust. And the first thing I tell counsel when they reach out is it's far more preferable if we can start with a trust that's in draft form and not been finalized or executed, so that when we make suggested revisions, it's easily accomplished. Sometimes when you have an established trust, it becomes a little bit more cumbersome if we need to look for revisions. Not to say you can't amend the trust. Certainly a revocable living trust isn't a problem, but if you're dealing with an irrevocable trust, there are some nuances there that make it a little bit more challenging, and some workarounds that we have to get involved with in order to accomplish that. But that said, once the trust is received, we review it. I will provide certain language that needs to be inserted into the trust document that provides protection addressing both the shareholder remaining the occupant, and then also things like the shares not being, or the co-op not being used for investment purposes. Also want to make sure that, in fact, if there are issues with the maintenance, that the co-op is in a position to bring an action to seek payment of the outstanding maintenance, and we're able to effectuate service, basically serve an interested, the necessary party, in order for the court to have jurisdiction. So we try and put language in there that ensures that that process will be as easy as possible. In addition to the language that we ask to be put in the trust, we also have several documents that we look to have furnished and executed. The first of which is an opinion letter from the counsel that prepared the trust to begin with, essentially stating that in that counsel's opinion, it's a validly created trust. So we would ask for that to be provided as part of the review process. Additionally, at the time of closing, what we look for is 2 documents to be signed by the shareholder slash grantor of the trust. The first of which is a transfer and occupancy agreement, and it essentially boils down to some key terms, indicates that the shareholder needs to occupy the unit during his or her lifetime, and that if that shareholder passes away, that it's not going to be used for investment purposes. We're also going to indicate in that document that the trust cannot be modified without board approval, and that it's also going to be subject to the governing documents of the co-op, i.e. bylaws, house rules, etc. So those are some key provisions in the occupancy agreement that we have signed at closing. And then to address the financial piece of it, we have the transfer guarantee the payments, the maintenance payments. So while the trust is the owner of the shares, the person that is transferring the shares into the trust will remain personally responsible. And in addition, there'll be language in there about how to pursue a default in the payments. So that's essentially the broad strokes of this area. I'm happy to answer any questions you might have, but it's definitely becoming far more commonplace for boards to allow for the transfer of shares, especially in the Westchester co-op community, I find.
So we do have a couple of questions in the chat box that I'll read. The first is, please explain the role of the surrogates court. What do co-op boards need to know?
Okay, so as Richard was stating earlier, if in fact there is, let's say the shares are not in a trust, okay, and you have to get someone appointed in order to represent the interests of the decedent's estate, you need to go to surrogates court. Each county has its own surrogates court. Westchester County is no different. There's a surrogate, and you would submit a petition to the court seeking the appointment of fiduciary to handle the estate and in turn deal with the co-op. So I can tell you that we many times we have situations where a co-op attorney will come to us and indicate that there's no family, that they need to do something because there's arrears accumulating. And in the case, as Richard was describing earlier, they look to have the public administrator appointed or to have the public administrator get involved. And that's something I deal with regularly. Just earlier today, we had a closing involving a situation where a co-op was in arrears of about $66,000. There was no family. And the attorney reached out to me as counsel for the public administrator and said, will you take this case? And from the public administrator's perspective, they want to make sure that there's at least some equity in the unit. That's critical, because if there isn't equity in the unit, then the public administrator is not going to pursue it, because they're not going to basically do pro bono work and solve the co-op's problem unless they know that they can sell the unit. And ultimately, the public administrator gets paid commissions for his services as the fiduciary of the estate.
Yeah, but just also, Russ, to follow up on you were talking about in terms of surrogates, why people want to put an apartment into a trust is either for estate tax planning or just because they don't want to deal with surrogates court. It's a way to pass on assets, and you don't have to go to surrogates court. You don't have to get someone appointed, and it's more private. And some people prefer to do things that way.
Yeah, no, absolutely. I mean, that's the whole point of the trust, is to avoid the surrogates court, completely. And that's, for the most part, I think that's the prime reason. There are some, tax reasons, but you really need to be talking about a very large estate from to be concerned about estate tax issues. You're really, I think, looking for the privacy component and the avoidance of probate. Those seem to be some key reasons why, at least in my experience, why people go to the trust route.
Actually, can I ask a question, Russ? I'm just curious. do you feel it's really important to have that language within the trust document if you have the ancillary documents about occupancy and, who's paying the charges?
It might be a little overkill, but I like to have it in there anyway,
Okay.
because, I will, in fairness, a lot, the language is similar in the separate documents that we asked to have put into the trust, but at the same time, it can never be in too many places. That's my mindset.
Okay, thanks.
We have another question on the queue. Could you briefly talk about a situation with a shareholder's last will and testament and the unit is willed to a family friend? What will that process involve?
Well, I think that, and Richard touched upon that earlier, you can have a will that might make a bequest of the shares to, in this case, a family friend, but that doesn't guarantee that that family friend will be able to actually occupy the unit. They're going to have to go through, especially in the case of a family friend. If it was a spouse or children, you have a better chance it would pass to that spouse or child. But if it's a family friend, that's going to have to go most likely through co-op board approval, and they might not in the end be approved, and the unit gets sold. They might get the proceeds from the sale, but they're
Right.
not going to be able to occupy the unit.
We have another question. If a shareholder transfers shares to a trust, does this keep the asset out of the Medicaid calculation? Some of our shareholders think this is a way to better qualify for Medicaid in the event that they go into a nursing home.
That's where you sort of distinguish between a living revocable trust and an irrevocable, like there's trusts called Medicaid trusts. Just going to a regular trust, a regular revocable trust, you're not going to be avoiding the issue of eligibility for Medicaid because you haven't given up control of that asset. A revocable trust, you still, by its very name, is revocable. So you have not given up control of the asset, and you could still pull it into your estate if you so choose. So it's still going to be counted with respect to eligibility. If you go to an irrevocable trust, a Medicaid planning trust, where you're essentially giving up control of that asset, then that becomes a way to try and avoid it being included for Medicaid purposes.
Yeah, I always tell my clients that they should consult with an elder care attorney because I know that there are a lot of nuances to it and that I'm not always on top of it. But I do know that those are things that you need to plan ahead of time because I know there are clawback periods where if you do it too late, Medicaid can say no, that's what you're trying to avoid, having to pay Medicaid, and we're not going to accept that transfer. So you really have to speak to someone that really knows what they're doing there so that you have the proper plan in place.
Yeah, I agree 100%. I do the same thing. When it comes to Medicaid planning, that is a very, concentrated area, and there's a lot of nuances to it. And I would typically refer that situation to a Medicaid planning attorney that's well versed in the tax code as far as how that all plays out.
The next question in the queue, other than spouses and domestic partners, can other relatives move into the apartment without board approval?
Well, I'm assuming because of the context of tonight, you're talking if there's a death, if the shareholder passes away, and really, you have to look at the proprietary lease because while most of them were written in the 1980s and pretty much say the same thing, there are sometimes differences, or a lot of our buildings, we've been updating the documents, and some boards have now expanded who has the right to move in without board consent upon a shareholder's death. They open it up to more family members, domestic, not cousins, but parents, children, things like that. So you really need to check the documents to see who's allowed to move in and take over the ownership of the apartment without board approval. I always advise my clients, though, to be somewhat restrictive because you want to maintain control. You want to make sure who's ever moving in has the financial wherewithal to carry the apartment. So, I mean, sometimes even a spouse, I mean, the shareholder who passed away was the moneyed spouse. And now the lease says the other spouse can remain, but that spouse might not have been working, who knows what's with the estate, and it could become a problem, so, but I
Yeah,
was, that's Russ, thanks.
no, I would agree. I mean, I think it's typical to see language about spouses and children. I think once you go beyond that, you're really the board's putting itself in a tough spot, and I would be very I wouldn't want to be overly broad on who you're going to let in without the co-op having the opportunity to interview and approve.
So those are the questions I have in the queue at the present. If anyone else has thought of a question, would like to either drop it into the chat box or use the raise hand feature, I'm happy to make sure that your question get asked. There is one procedural question here, which is about sharing the recording for the review. As I had mentioned at the top, we will be sending out a quote unquote highlights video with which attempts to summarize some of the comments that the gentleman said. That should follow in a couple of weeks. I had mentioned that we would share PowerPoints, but neither of the gentlemen used a PowerPoint, so there's nothing to share.
Yeah, I would, Tim, I would also say I'm happy to provide my office number and email. If anybody has a question they want to send directly, my office number is 914-644-8300. And my work email is rjellinek, JELLINEK at S as in Sam, G as in girl, -law.com. Feel free to reach out, and if I can help in any way, I'm happy to do so. Whether it's a transferring to a trust, or if you have a public administrator question as well, because I routinely get calls from attorneys asking for assistance in public administrator matters in Westchester County.
Likewise for myself, actually, I'm going to type in my info into the chat so you can all have it, and I'll give my phone number and email, and we represent about 80 co-ops and condominiums, so we are transfer agent for several of our buildings, so always happy to answer questions and see if we can help you out.
There are a couple more questions. What are your opinions of going all into condos versus co-ops? Curious.
Want to take that, Richard?
I was just typing, but I'm sorry, the question.
What are
I'm
your
not sure.
opinions of going all in to condos versus co-ops? Curious.
All
What-
in?
What does that mean?
Yeah.
Should we buy a co-op or condo? Is that really the question?
Not sure.
I mean, that's I don't know, it's a hard question to answer. There are obviously pros and cons of both types of ownership. And some of that's also reflected in price, carrying charges. So I think there's a lot of things you have to look at before you decide one way or another. I know that a lot of people feel they want to do a condominium because it's less restrictive and they have more flexibility in terms of selling or subletting. But to be honest with you, a lot of my condominiums now are coming to me and they're trying to institute co-op rules because they want that control over who's in the building, and they're trying to control the finances of the building, and they're trying to implement co-op rules, little by little. So that's changing a bit. So I don't know if, depending on the condo, you might find yourself in a situation where they're also a little restrictive on what you can do. So it really depends on where you're looking in and what the choices are.
Yeah, I would add to that also, as far as the co-op is concerned, given that form of ownership, you really want, as a potential purchaser, do your due diligence, because if you really want to be comfortable from a financial standpoint, because if the co-op's in a bad financial state, ultimately that could really hurt you down the road. So, and many of my co-ops are in very good financial shape, so it's not an issue. But unfortunately, there are those that are less fortunate, and if you're buying into one of those communities, it could become a challenge for you.
We have a couple more questions in the queue. Who initiates a transfer of shares when a shareholder passes away?
Well, usually that would be the, assuming there's an estate and you have an executor or administrator appointed, that would be the person who would be initiating this, the transfer of the shares and selling the apartments. But sometimes if they're, I've seen situations where there is an estate and there is an executor, and for whatever reason, they're not paying the maintenance and they're not really doing anything, and, then we have to get involved and start serving notices that, they're behind in the payment of maintenance, and we're gonna terminate the lease if something doesn't get done, and that lights a fire under them. So sometimes, it might be actions that we take that gets the ball rolling, because, we can't, you don't want to be in a situation where the arrears get, out of control. Every co-op and condo, you have a budget, and, some buildings, one unit owner or one shareholder not paying could have a big impact on, paying the bills.
Next question, does the public administrator do the search for relatives when a shareholder is deceased? Or is this the co-op's legal counsel who would do this?
Well, I'm sorry. I would start and then I'll hand it over to Russ because he knows better than me. But we try our best initially to see what we can find out, but we can't really have access to the apartment and things like that. So unless it's fairly easy to find, we'll Google, we'll search the managing agent's files to see if there's contact information from somebody else. But once we are at a standstill, we go to the public administrator, and I'll let Russ talk more about that.
Thanks, Richard. I will say this, in Westchester, if someone comes to us and looking to have the public administrator appointed, we would, as I said earlier, number one, make sure there's equity in the unit. And number two, the council would have to provide us with as much information on family as possible. The public administrator doesn't have, resources to be spending money tracking down potential heirs of a shareholder that's passed away. We essentially want a package of information that we can then put into the necessary paperwork for the court without having to, do exhaustive searches for individuals.
And I guess to follow up, I realize now, Russ, that I was very fortunate because my two apartments where we have the public administrator, one is in a fantastic building in downtown Brooklyn, and the other one's in a really good, exclusive building in the city. And I guess the apartments are worth it, that they know they're going to get paid. And so they actually went to the apartments to see what they can find, and they're taking the time because I guess they figure, it's going to be worth it down the road.
Yeah, a lot of times we have a lot of situations where the co-ops are of there's marginal equity in these co-ops. So it becomes a situation of whether or not it makes sense for the public administrator to get involved if there's really, once the co-op is satisfied with its arrears, whether there's enough left over to make sense for the public administrator to, get involved with the process.
Are there other questions that folks would like to ask? I do not have anything in the chat, and I don't see any hands raised. Oh, here we go. Scenario, a shareholder died 5 years ago, bills get paid, but unit is vacant. Is there a suggested time limit on when a board pushes the estate?
That's a good question. That's, if the maintenance is being paid, obviously you're very happy because it's not having a financial impact on you. But I would, look, it depends on the building. I mean, most of my buildings, they want to see shareholders who are occupying their apartments. It just makes for a better community. And I guess there could be some security concerns about an empty apartment. So, I'm surprised it's been 5 years. We would probably reach out at some point, and, actually, I think we're in a situation now with the building I have in Upper Manhattan, where we reached out to the estate, like, what is your plan? Like, we'd like to see it sold and get a shareholder in there. I mean, they've been paying, that hasn't been an issue. But they want to have a neighbor. So we're trying to light the fire a little bit.
Yeah, I would say that's a pretty rare scenario too, that if for maintenance to be being paid for 5 years and nothing happening, because people aren't going to just be sinking money into a place for 5 years without there being some end game there. So that would be the rare exception, I think.
The next question, oh, I'm sorry, someone comments, we had that situation for 10 years.
Wow.
Really?
It's crazy.
Well, things happen, but I would not expect that to be the norm.
Next question, what does the co-op do if there is no equity in the unit and the public administrator won't step in?
And I'm assuming that there's no maintenance being paid. Typically, when no maintenance is being paid, I try to go the route of a non-judicial foreclosure. But in this particular situation, I would probably commence a non-payment and go into court and see if somehow I can get the court to appoint somebody to take over the interests of the apartment, and so that we can get someone appointed and sell it.
Yeah, I can tell you that in Westchester, what happens routinely is that if there's really no equity here, that the PA wants to get appointed to handle the estate and handle the ultimate sale, what he will do is be appointed for the limited purpose of accepting service of the paperwork in a non-judicial foreclosure sale. So it allows the co-op the opportunity to proceed with its foreclosure, have somebody to serve the papers on, with the understanding that the public administrator is not going to defend the foreclosure. He'll simply accept the paperwork to allow the co-op to move forward with the foreclosure.
And Russ, correct me, but I think like we had that situation in the building, and after the apartment was sold, I mean, the money's not really ours. And we ended up giving it to the controller of New York State to hold on to. And we just got, our arrears, our legal fees, whatever we spent and laid out, and whatever was owed, but it's not like we made a killing on selling the unit.
Yeah, what happens in some instances where there's a, let's say they come to the public administrator feels there's not equity, so he's not going to get appointed as to handle the estate, but he does allow for the foreclosure of the unit by accepting service of the necessary paperwork. The co-op proceeds, they foreclose, and there actually turns out to be a surplus. Perhaps it's sold for higher than anticipated. In that scenario, what sometimes happens is the public administrator will then get appointed to take that surplus funds and, move forward accordingly, which if there's no family members, ultimately the money would go back to the controller anyway. But so the only one that's really benefiting there would be the public administrator, because he'd be receiving his statutory commissions for serving in that role.
We have an empty queue at the moment. We probably have time for one, maybe two additional questions. Does anyone have anything that hasn't been asked that they would like to ask at this time? There we go. This may already have been covered. What happens if the shareholder dies without a will? I think that was covered earlier.
Yeah, I mean, if there's no will, that does, that depends on a lot of different situations. If there might be another shareholder, or if there's no will, if you have contact with a family member, they can still go into surrogate's court and get appointed as an administrator. If there's a will, it's called executor. If there's no will, it's an administrator, and it's more paperwork. But you can get appointed by the court and deal with the asset. So that doesn't necessarily slow you down. That doesn't mean you can't do anything necessarily.
Yeah, the statute, the New York statutes provide a certain priority as to who can serve as an administrator in the absence of a will. Usually it's spouse, children, parents, and it works its way down. Further down on the list is the public administrator, actually as a default person. So that's that's where the public administrator comes into play as well.
All right, this will be the last question. A neighbor died 8 years ago, but his car is still in the garage in a storage area. What can be done?
Tow it.
Yeah.
After 8 years, I would just tow it.
Simple question, simple answer. So with that, I want to thank our two speakers tonight, Richard Klein and Russ Jellinek, for providing first-class education on a sometimes very complicated issue. And with that, I want to turn it over to Jeff and Jane.
Thank you, Tim. And I want to add my thanks as well. This has been highly informative. So thank you to our speakers. And thank you to all of you who are here for your wonderful questions. So a couple of closing remarks. First of all, you will be receiving a follow-up survey on tonight's meeting. And one of the questions you will be asked is whether you have any suggestions for future meeting topics. So please, if you do have issues of interest that you'd like to hear us present on, let us know. Because that goes, and one of tonight's topics, in fact, came from a previous survey. So please be looking for that. It'll be coming to your inbox. And secondly, also be looking in your inbox for a notice of our upcoming March membership meeting, topic to be announced. And so with that, I will say good night and wish you a continuing Happy New Year.
Thank you.
Thank you, Jane. Russ and Richard, great job. Great job. Thank you.
Thank you, everybody.
Thank you. Have a nice evening, everyone.
Good night, everyone.
Good night.